The United States District Court for the Southern District of Iowa is now in session. The Honorable James E. Gritzner presiding.
Take a seat, please. Good afternoon.
Good afternoon, Your Honor.
Your Honor. We are convened in the matter of West Liberty Foods versus Moroni Feed Company, number 10-146, on the plaintiff's motion to vacate in part and confirm in part the arbitration award, the defendant's motion to enforce judgment settlement for confirmation of the arbitration award, and the notice of fraud. This matter will be video recorded, and the video may be posted on the website for the federal court system and this court's website. The parties to the case have agreed to allow cameras operated by the court to record the proceedings. So please limit noise, side conversations, and other disturbances. And we have already limited the router that was driving us all crazy. So hopefully it'll be a little bit quieter. I would anticipate, given the posture of the pleadings, that it would be appropriate to hear from both sides twice. So I'll start with West Liberty Foods, and we'll just go back and forth a couple times so that you both have an opportunity to respond to one another. Mr. Tank?
Thank you, Your Honor. Can I remain seated?
Can you be picked up by the camera if you remain seated?
Yeah.
Okay, yes.
Thank you, Judge. May it please the court, we're back. We were here
back
several years ago, and we've come back after some effort to resolve our differences pursuant to your order. We have filed a motion to vacate, a motion to confirm, and a resistance to a motion to certify, and also have brought to the court's attention a matter that we feel may bear on the court's ruling, that namely the notice of fraud that we have filed. Although the case and the posture in this matter is a bit complex, it is our view that there are two essential questions that the court should consider and address in ruling on the various motions. The first question is simply whether the award that was entered by the arbitration panel qualifies as a reasoned award as to the prejudgment interest included in the final award amounting to $2.1 million. The second issue that we think is ripe for the court to consider is the significance, if any, to the court of the affidavit that had previously been filed from Attorney Johnson that we believe the record now demonstrates was a false affidavit. On the motion for partial vacation, I'll start with that. On the reasoned award issue, if that's arbitrators have virtually unfettered authority, and the court's mindful of that, and so is the plaintiff here, West Liberty Foods. We understand that when we enter into an agreement that submits something to arbitration, if in fact that's what our agreement did, but if we were to arbitrate that dispute, we give up certain rights that we would have in court. Everyone knows that, and I am mindful that in order to persuade the court to vacate part of the award here is a burden, and it would be unusual, I think it's fair to say, for the court to enter such an order. Having said that, I think it bears mention that the powers of an arbitration panel are governed by the parties to the arbitration. In other words, it is the parties' agreement that enables the panel to do its work. It is authority from the parties that is given to the panel. And the panel must operate within the specific authority that has been given them by the agreement. In this case, the panel was required, pursuant to the contract, it's not really in dispute here, they were required to enter what is known as a reasoned award. In other words, they had to provide the parties some explanation as to the outcome of the arbitration. Under the Federal Arbitration Act, this court can conclude that if the panel did not comply within its authority, in other words, if it entered an award that was not a reasoned award, that would be in excess of their powers. They would have done something they were not authorized to do, and the court, based on that finding, could vacate the award. So the question really is, what does that mean? What is the requirement for a reasoned award? And there are not many cases that I was able to find, Your Honor, that really put a lot of meat on that bone. But I did find a pretty clear consensus that a reasoned award is something short of findings of fact and conclusions of law. Doesn't have to be that, but more than a simple result. So it's got to be something, it cannot be nothing. The mission, I think, is to review the four corners of the award. It was labeled an interim award, but that constitutes the logic and the findings that were made by the panel, to find or discern whether in that document there was an adequate explanation for the substantial prejudgment interest award that was made by the panel.
You're answering one of my questions, I think, but let me be sure, and that is that in determining whether or not it was a reasoned award, I can look at the entire document.
Yes.
Rather than simply the section that deals with prejudgment interest.
Yeah, well, if you can find discern a basis, yes, you can.
Yeah, and then the next question is, must it be an express explanation, or can the explanation be gleaned from the remainder of the document without an express statement to that effect, but it's a deduction that is obvious from the document?
I think it can be inferred. The question is whether the language in the award allows the court to make that inference. In our position, both before the panel and here, is that the issue of whether prejudgment interest was appropriate is based on a different factual standard, and in fact a different legal standard than applied to any of the issues that were addressed in the award. So again, we raise the issue, we say it's not there. That's the challenge to Moroni. Point to it, explain why the court should either make a finding that it's there, or that would enable the court to reasonably infer that based on what the panel said, they did in fact decide the issue of prejudgment interest. And as to, I don't think so far we're really far afield with Moroni on the law. It's got to be a reasoned award, and it's got to be something more than nothing. The arguments that Moroni makes in support of this prejudgment interest are really twofold. The first one is to argue that, you know what, this prejudgment interest issue was such a utterly trumped up issue, and the panel really was not obligated to deal with it at all, and the court can infer from their failure to address it that they just ignored it. Moroni says, I don't want to misquote him, and I'll quote him directly. Obviously, The failure of a panel to address an argument that is without any basis under the relevant law cannot give rise to an argument that the panel's decision was not reasoned. They go on to say, West Liberty Foods' legal argument against Moroni's prejudgment interest award was so utterly without legal basis that it did not merit any discussion in the award. Well, we think that there is a robust issue on the entitlement to prejudgment interest. The parties identified the issue in their submissions to the panel, separate, independent of the other issues, and the parties briefed the issue of prejudgment interest separately and independently of the other issues. So it was not a throwaway argument that didn't need to be assessed. It was a real bona fide dispute between the parties that required some comment. The second argument is where the court's question leads us, which is, if the panel said enough about something other than prejudgment interest that would adequately support the prejudgment interest award, isn't that a reasoned award? Can't the court construe it as they've said enough? They didn't identify, there's not a subsection in the opinion, there's not a specific discussion about it, but they said enough in their award that the court, before you endorse this award, can feel confident that it was a reasoned award for prejudgment interest. And the argument that Moroni makes in support of that position is the following. Prejudgment interest is justified based on the panel's finding that West Liberty Food breached its contract with MFC. I think that's a proper argument. In other words, if the court were to conclude that the facts and the law necessary to support an award of prejudgment interest are the same facts and the same law that supported a finding of a breach of contract, the court could reasonably conclude that the panel in fact addressed the issue, even though they didn't speak of it particularly. The problem with that is based on the fact that this issue of prejudgment interest was not based on the same evidence and involved a different legal standard than would enable the panel to find a breach of contract. And I know we're not here to persuade you that the Utah law doesn't allow prejudgment interest, but in order to determine whether you can infer from a finding of breach of contract, there's enough there to conclude that under Utah law, interest is the normal incident or naturally and automatically flows. We've addressed Utah law in our briefs.
You have the examples that you cite seem to be, for lack of a better term, more egregious than the situation that we have here, in that there are some very large and significant gaps in the record available in those cases. What is missing here to enable, under the Utah standard for prejudgment interest, what is missing in this record to reach that conclusion?
Based on the Utah law?
Yes.
In order to award prejudgment interest under the Utah statute, the court would have had to have made a finding that the damages here were established with the requirement that would enable the court to say that
I think the standard is that the damages were ascertainable and mathematically calculable, as I read the Utah law.
It was unclear to me reading the Utah cases exactly what the standard was. You're right, of
But
course,
you can see what's missing in those cases. It's pretty clear. And so my question is, to make sure I'm comparing apples to apples here, what is missing here in order to reach the conclusion?
In the award, what could they have said?
Yes.
Oh, well, here's what they should have done in my...
What did they not have in order to make the decision?
Well, they had enough. I mean, the evidence was presented to them. I don't mean the weight of the evidence supported the award, but there was enough information in the record that they could make that decision. And the Utah cases that talk about compensatory awards on the one hand and prejudgment interest on the other draw a clear contrast. And like Iowa, they say that in order to sustain a compensatory damage award, damages must only be established with reasonable certainty, or there must be some reasonable basis, rather, on which the record would support the damages. It's more forgiving. What the panel should have done is to address specifically the related but separate question, in this case,